So good morning everyone, and welcome to our instruction course on medical legal challenges. So outset, I thank the organizing team of APAO and the scientific team for this opportunity. And why this course matters? Because we face, as ophthalmologists, we face dual challenges. One is we have to excel at the clinical level, satisfy patients, and also with the growing tendency for medical legal challenges, we also have to deal with the legal and ethical complexities. So this course is basically on how to protect patients as well as protect our practice, and use this medical legal knowledge as our best preventive strategy. So practice of medicine used to be an art and not a trade. It was a calling and not a business. So now, unfortunately, whether we like it or not, it has become a trade and more so considered as a business by government and all other stakeholders. So today's program is starting with the statutory and legal requirements for an eye hospital. So the most important requirement, and then we go on to the other talks. So we all know in modern healthcare, documentation is not just good practice, so that is the best defense. So that will be adequately covered with our faculty. Dr. Murali Ariga is a glaucomatologist and medical legal expert. He has a dual degree on both, has expertise and experience in glaucoma with a professional degree in medical law from the National Law School, Mumbai. Thank you, Murali, for joining us today. And we also have Dr. Sendil Kumar, who's again has dual degrees and expert in both ophthalmology and legal matters. He is currently the chairman of the PPLSS and have been involved in analysis of many legal cases related to ophthalmology. The most important medical instrument is not the laser or microscope what we use, but the pen that documents informed consent. And that will be adequately highlighted by Dr. Satyan Nagamalai, who is again a glaucoma expert and expert on patient consent protocols and documentation. And we recently translated the legal consent forms into practice guidelines in both English and Tamil. Dr. Niranjan is an upcoming medical legal expert. Apart from being a young ophthalmologist and active in many associations, he is also pursuing a degree in PGDMLE from the National Law School. And so with this team, I'm happy to share our experience and expertise in medical legal matters. I'm Dr. Nirmal Frederick. I'm currently with NABH and a practicing ophthalmologist at Chennai, and dealing with practice related matters, and also currently the chairman for the insurance committee of AIOS. So to all our delegates who have joined today, hearty welcome and thank you for joining us. So hopefully you take valuable pearls from this session regardless of your career stage, because the legal landscape affects all of us equally, and today's knowledge is the practical armor for our daily practice. So please do take notes, that's to keep you awake. Prepare questions for the panel. We have adequate time for panel discussion. You can also share your experiences and scenarios. So let's learn from each other's challenges. So with this, I start my talk on regulatory compliances. And my talk is not based on the legal books, but my experience as a healthcare assessor during assessment of in national as well as international area. As a doctor managing a eye care hospital, and what are the difficulties I face in getting those licenses and compliances. And also as an office bearer of many professional organizations, and also making the eye care standard and as chairman of the eye care standard NABH. So I'll be talking more from my experience, and there will be some references. So why it is important? Because that's the right thing to do. to be on the right side of the law, and being righteous is the most safe thing we can do in our practice. And it has its own benefits apart from government approval, access to government resources and lenders' resources. It also involves patient safety and our credibility and risk management. Of course, complying with the legal requirement is time consuming, costly, and of course, a lot of corruption and resource intensive, because our people have to follow it up at the right time with the right people. So, the objective of this talk is to highlight the requirements, help to understand the important licenses, and also to a certain extent how we can minimize the burden of compliances. So, before going to this, we need to understand the regulatory requirement, why it is needed, because it is safety, quality assurance and ethical practice. And what are the specific regulation to eye care practice? The first and foremost is the Clinical Establishment Act, and of course fire NOC, biomedical wastage are all important. And when there are timelines for each compliances, some are 5 years, some are 3 years, some are every year, and some licenses are for perpetual. That means once you start, you need not bother about it. And where it should be filed, so it all depends on the state. In India, health is a state subject, so you have to deal with your state authorities. And who's responsible? It is the prime responsibility of the leader of the practice, of course the management, and you can allot an administrative person to deal with the compliances. So how do we do that? We need certain documentation, some training for our people, and also frequent audit and reporting. Let's go one by one about the requirements. And these are the basic things, duties of a doctor. So whether we like it or not, we need to know the provisions of all central, state, local authorities act, and non-adherence or ignorance of law is a punishable offense. So ignorance is not a bliss here, it will be a punishable offense. So we need to highlight this. 70% of hospital owners who are running the practices for so many years are unaware of the laws regulating their area or specialty. And most of these law or requirement compliances are misunderstood by them, especially the consent laws, the prescription requirement, everything. So it's unfortunate that many of our doctors are either unaware or have misunderstood. So the current landscape is, these are the requirements. So we need to understand compliance is not a burden, but a bridge to credibility, trust and excellence. So when we do the right things, right success follows. It's important that we know the compliances and follow the thing. I'll start with basics. So regulations is nothing but an instrument mandated by the government to impose certain set of conditions that the eye care organization must comply before and after it is permitted to operate. So some of them are relevant to even start your practice. So compliance means you are following the requirement of the law. So these are the basic sources of healthcare law. One is the statute, second is the case law, and third is the code of conduct. Code of conduct is issued by the National Medical Council Commission for all of us. So regulations, there are certain things specific for medical field only, and there are other laws which are specific for certain other areas of operation. Like for ESIPF is the HR requirement, digital health is now coming up. Case laws, these are requirement based on the court judgments, both High Court and the Supreme Court judgments. So the consent laws are based basically on these case laws. And third is the code of conduct, both for doctors and nursing. Now there is a code of conduct coming for our paramedical people, issued by the Paramedical Council of the state. So general opinion is healthcare is under-regulated, but once you go through these laws relevant for hospitals, you know that. So we are the most regulated profession in India at least. So these are the 4 laws relevant for hospital. So one is the registration and licensing requirement. Second is the Common Act law, which is applicable for even daycare centers like us. Third is the law specific for functioning. And fourth is public health legislation. For example, if you detect a TB, you have to notify to the authorities. That is a requirement. So these are the responsibility of management, and the most important license for hospital now is the Clinical Establishment Act, This is valid for 5 years and various highlights are there. I'll just go to the, so it depends on the type, size of our practice. So it can be single practice, polyclinic, daycare, or as a hospital or nursing home. So you have to register on the appropriate category, and most of our eye care centers are daycare centers. So some states have specific registration for daycare facilities, and these are the requirement. You need to follow the fire safety norms. You need to have a biomedical wastage MOU with vendor, and also should have referral mechanism for emergency patients. So this is including the daycare centers. So you need to have provision for emergency care. And these are the infrastructure requirement under CEA. So this is common for most of the states. So minimum space requirement, and there has to be mandatory equipment. All these are listed in the Clinical Establishment Gazette. You can go to your state gazette and download all those things. So these are the three categories and code under the clinical establishment, either hospital, clinic, or optometry services along with this. So there are many interlinked regulations here. Standard treatment guidelines have to be followed. You also need to submit certain statistics to the state authorities, and you need to charge the rates and procedures within the range of rates. And there are various variations across the states, and these are the additional challenges. So let's have some compliance, clarity on the compliances. So basically we can divide this into building and special norms. So when you start a building or occupy a building, you need to have building permission, and you also need to follow the National Building Code for the adequate space, lighting, ventilation, continuous potable water, and power supply. And second is the daycare center additional requirement. You need to have a minimum one critical area, so which should follow the general OT norms of NABH guidelines. Zoning is now mandatory under the clinical establishment. You need to have 4 zones for the operation theatre. AHU and backup power supply, emergency medication, all these are necessary and part of the Clinical Establishment Act. The second aspect is we need to provide safe and hazard-free environment. So do no harm is a basic mandate. We have to ensure there is structural and non-structural safety for in our building. Apart from that, the most important thing is we need to focus on the critical systems like emergency exit system, fire system, electricity backup, water supply, both clean and support water supply. We also need to ensure medical gas supply system. And fire NOC is mandatory in many of the states for public buildings. In some states, less than 15 meters, it is excluded. So it depends on your state laws. So in case you don't have a fire NOC, you need to have a fire safety audit done and get a audit certificate from the authorized vendor. So this is part and parcel of our NABH standards. So mandatory licenses for all eye hospitals is the Pollution Control Board license. You need to get the consent from the PCB for air, water, and biomedical wastage. And you also need to have your land and building value audited statement. And this NOC can be obtained for 5 + 5 years or 3 years. And this authorization is mandatory if you are generating biomedical wastage in your theatre and OPD areas. You need to have a MOU with the local vendor. So you also need to comply with the waste segregation, amount of waste segregated, and how you are submitting this, and you need to maintain the records for all these things. So in some local authorities, they have this trade license. So if you are running a pharmacy or optical shop, you also need to have the Shop and Establishment Act registered. In some states, they want even the hospitals to have trade license. So the fourth point is manpower. You need to ensure all registered doctors are registered with your state medical council, including the additional qualification like MS or DO or DNB that has to be registered. And some states ask registration in their own state to practice the specialty in that area. Nursing, only the GNM qualified nurse is recognized as a qualified nurse. So a PMOA, optomes, the MLOPs, vision technicians are all paramedical staff. They are not taken into account as a recognized nurse. So ensure they are also registered with the paramedical council. So the conduct of nurses and doctors, the NMC norms have a moral authority and legally binding under the law of torts. You also have to display the register number and ensure registration numbers is given in all prescriptions, certificate and money receipts. And if you are giving certificate, please ensure this date, sign, signature is followed, and there is an identification mark of the patient, and always keep a copy of the certificate for your record. And this again is an important part of the NMC norms, membership in medical society. So you can proudly say that you are a member of a recognized medical association. The fifth point is providing safe storage, preservation, prescription and dispensing of drugs under the Drug and Cosmetic Act. If you are running a pharmacy, you need to have a retail license, and if you are giving narcotics in theater, so you need to have a NDPS license. Of course, minimal amount the anesthetist can handle. So ensure you have a license, and so you need to apply to the drug control department for pharmacist details and engage a licensed pharmacist for guidance for all these activities. You also need to maintain certain registers like drug inventory, purchase and sales record. So pharmacy registration is mandatory. There are certain requirements, space and facility requirement. We need to follow this. This license valid for a period of 3 years. The sixth is HR. I've already told you the requirement for doctors and nurses. Apart from that, if you are employing more than 20 staff, you need to register under the PF. If it's more than 10, under the ESI. The Professional Tax, Gratuity, Minimum Wages Act are all related to these HR statutory compliances. But this PF and ESI is mandatory. Please ensure if you exceed 10, you need to register with these two authorities. The seventh point is medical records. With insurance coming up in a big way and attaching to the National Health Exchange, so this Digital Act, digital protection are all important aspect. You need to have the statutory documentation. So minimizing the compliance burden, whether we like it or not, corruption is part and parcel of the compliance requirement in our country. There are recurrent costs, delay and demands, and administrative workload, high operational costs, and also documentation overload. So it is unfortunate, but we need to follow this to be compliant. So to improve compliance, government have to reduce complexity, reduce confusion, make it as a single window clearance, and timeline have to be increased. So these are the mandatory. In our part from NABH, we will reduce the mandatory requirement. So only these 4 are required: Clinical Establishment Act, Fire Safety Norms, Biomedical Wastage, and if you have a pharmacy license, and registration for doctors and nurses. So we need to have a mechanism to regularly update licenses. So this is the Excel sheet to maintain that, and this is the compliance matrix. We need to diligently follow this and have a compliance calendar of all the requirements. And how associations can help. So most of the associations are now involved in serious advocacy to streamline all those things. And in our part, we also put all this requirement into a book format. And this is the AIOS CME series. Hopefully it will be released today evening, called as Focus. So thanks to the AIOS leadership and IJO, we are bringing out this book, and it should be available to all the AIOS members through the website. So basically, ensuring safe practice is important. So we need to ensure they are integrated into the day-to-day functioning of the hospital. So ensure compliance to face medical legal cases boldly, and compliance with basic laws are very important for ethical functioning. So compliance to regulations are necessary, but need optimization. So for our own safety, we need to comply with all these statutory requirements. So I am sure there are many unanswered questions. We can take up questions during the end of the session. Thank you so much for your kind attention.
Where you get daycare center registrations?
Yeah, Satyan, can you start? I'll answer the question.
Yeah.
Okay, so daycare registration is part of the Clinical Establishment Act. It is there only in some states, right? So for example, in Haryana it is there, in Rajasthan it is there, part of the clinical establishment. So Clinical Establishment Act, it's open for hospitals, polyclinics, labs, daycare centers and the clinics, single doctor clinics.
The nursing home registration is must for daycare.
It depends on your state law, sir. In Tamil Nadu, nursing home registration is mandatory if you have an operation theatre.
Daycare center we can operate, sir?
No, if you are having a critical facility like operation theatre, it is classified under the nursing home category. So you need to have beds to support your operated patients. At least 2 emergency beds have to be there. So then it automatically becomes a nursing home.
Some places cardiac surgery is in daycare is also like USA.
No, US and Gulf countries are different. They have Ambulatory Surgical Care Act. So patient can be operated in this ASC center. It's called ASC center, Ambulatory Surgical Centers. Unfortunately, it is not available in the Indian laws. Yeah, so we now go to the second part. I've already introduced Dr. N. Satyan. Over to you, Satyan, for this important talk on consent and its cruciality.
Thank you, sir. Good morning, everybody. I thank AOS, APOA, and Nirmal sir for this opportunity. I am here to talk on consent and its cruciality in our practice. So, what is consent? It is an agreement, compliance, or permission given voluntarily, very, very important, without any compulsion. In medical practice, it refers to a willingness of a person to subject himself for examination, investigation, or treatment. And more than your skill set, you are no more considered as God. So, consent is very, very important. Without a consent, never ever touch a patient, do a procedure, or operate. So, consent started in 1947 with Nuremberg Code, then Declaration of Helsinki came in 1964, released by World Medical Association. And according to our 1872 Indian Contract Act, there was a proportion for consent. So, what are the types of consent? It is implied consent and express consent. And under the express consent, you have verbal or oral, written or informed, blanket, and third party. So, what is implied consent? Given automatically by the patient by virtue of his action. Moment he walks into your clinic, he has implied his consent to get examined. So, implies that he is agreeing to be examined. Only for procedures like inspection, palpation, percussion, auscultation, or just rolling up their sleeves for blood withdrawal, and not for any interventional procedures. Don't ever think that he has come to your clinic and can start doing procedures or a minor procedure or an intervention. Coming to the express consent, verbal, specifically stated by the patient in his own language, for relatively a minor examination or therapeutic procedures, like in case of ophthalmology like syringing, appellation tonometer, gonioscopy, all can be brought under. You have to tell them that I am going to do this. I am going to touch your cornea, do an appellation tonometer, touch your cornea, do a gonioscopy. I am going to insert a syringe to do a ducting or a syringing, and that is verbal consent. And you need to have a disinterested party like a nurse or a relative with them during that procedure. Then coming to the written consent, for all major and diagnostic or therapeutic procedures like surgeries and anesthesia, you should have a valid written consent. And if you are doing any research, then participation in medical research needs also a consent, and it has to be in vernacular language, both in English and your local language, or the language which patient understands or knows how to read and write. Then coming to the doctrine of informed consent, condition, or it should have following in it: condition or nature of illness, procedure or the treatment proposed, risk and benefits of the treatment, alternative treatment and the risk and benefits, and prospect of success or failure, that is prognosis, prognosis of absence of intervention. If they are not ready to undergo that intervention, what will happen if they don't undergo that intervention, and acceptance or refusal or informed refusal for the said procedure intervention should also include in the doctrine of informed consent. So, a doctor should have multiple ways of explaining therapy, alternatives, benefits, harms, risk, etc. It might look very complex, but it is mandatory. and the level of understanding of that procedure and the risk associated with that procedure will be examined by the court of law when they have a case against you. Sorry. So, what is Bolam law or real consent? In case of informed consent, it is the doctor's responsibility to disclose the necessary information to the patient, but what court expects is a real consent, where apart from the procedure you have to also explain the risk associated with that procedure, which they consider as a real consent. So, you should have three things: elements of real consent should give voluntarily without any correction. Patient has the capacity and competence to give consent. They should be mentally stable to give that consent, and they should have an adequate level of information about the adequate level of information and adequate level of understanding about the procedure. And aging of consent less than 12 years, consent is invalid if the child signs a consent form under section 90 of IPC. Parent, guardian or person in whose custody he or she is can give a consent. 12 to 18 years effective consent they can sign, but level of understanding is very, very important. More than 18 years, any person with sound mind can give a consent. So, consent in emergencies: failure to get a consent during a medical emergency, like you have a globe rupture, corneal tear, something like that. If patient is conscious, you can get a consent. If the patient is not conscious, you have a road traffic accident where you need to treat the cornea, then it is not, if you don't get the consent, it is not amounting to any battery. Medical or not the legal considerations are important in life threatening situations. To take a written opinion from expert colleagues and at least get a signature from the next of the kin possible, police or the hospital in charge in case of an emergency. This is a famous case between Dr. T.T. Thomas and Srimati Eliza, where perforated appendicitis was not operated by Thomas since there was no consent. So, patient had a problem, and then he was held liable because he didn't do the surgery during emergency despite not having a consent. So, rules of consent: it should be free, volunteer, clear, intelligent, informed, direct and personal. Ideally in his own handwriting. Printed format can be a uniform format, can be printed formats, but rest other thing, specific risk, specific complication explained should be in their own handwritings or your handwriting, and they should read and write and sign it. And it should be procedure specific and person specific. See, you cannot get a consent under your name for somebody operating on that patient. See, you have a visiting consultant, like a retina consultant visiting you, and you cannot sign for them instead of a retina consultant. When person undergoes a retina procedure and done by the retina consultant should sign the consent form, not you. So, it should be procedure specific and person specific, and consent for each procedure. Like you are doing a cataract, somebody else is doing a retina procedure, you should get two consents. If I am doing a trab with cataract, I get two consents, one for the cataract, one for the trab. So, it should be procedure specific. Separate, leave out blood transfusion. Insane and intoxicated person, somebody not very with acumen, then unable to understand the nature and consequence, consent is invalid. So, you have to get a sign of the accompanying person and all those things. So, this is one of the famous where patient was taken up for a laparoscopic inspection, and they found a problem with uterus, and consultant came out, got a consent from the mother of the patient and did a hysterectomy and oophorectomy. So, that is invalid and the doctor is held liable. So, consent of spouse is not necessary for any treatment other than performing sterilization, and these are all for general thing. Consent is invalid if it is not an informed consent obtained by misinterpretation, representation, fraud, threat or violence, under sedation, failure to get proper information, no legal capacity to give it, a minor or insane person, different procedure, different physician. And in ophthalmology, which is not negligent, which is negligent, if you have a nucleus drop, if you don't have a thing to facility to operate immediately or retrieve the nucleus immediately, that is not negligent. Not able to calculate the exact IOL power, not negligent. Dislocation of IOL, then patient not following instruction, not compliant, then resulting in a complication, you are not liable. YAG laser leading to causing RD, not negligent. MI during a minor procedure, drug reaction, and not identifying the drug reaction and is an offense, but having a drug reaction is not an offense. Adverse events due to product issues like IOL, consumables, visco, BSS solutions, you are not liable. But when you don't have a valid written consent, it is a negligent. B scan not done for a mature cataract, end up having a noting an RD later is a negligent. Failure to record vision, IOP, duct, blood sugar, BP, and if any fitness required, it is a negligence. Consent for one procedure performing different or additional procedures. Failure to perform emergency procedure or surgery. Failure to identify drug reaction is a negligence. And not having a required license, as Nirmal sir said. Lot of hospitals had a problem because they didn't have the Pollution Control Board or as a Clinical Establishment Act to do the procedures there. So the compensation ranges from 2 lakhs to 1 crore. Recently, failure to detect retinopathy of prematurity, the patient was given 1 crore as a compensation. So compensations are increasing leaps and bounds. You should be very careful. So we did convert our AIOS English to Tamil, and you can see consent in all languages of your choice, and do use those consent both in English and your own language. And as sir said, we have released our contents there. Thank you.
Yeah, thank you, Satyan. If there are any questions, we'll take after the session. So now I invite ophthalmologist as an expert witness. So we are all can be called as expert witness for court proceedings, either for compensation cases or negligence cases. So how do we take that? It is indeed a challenge because we are used to operation theatre, not the court dynamics. So how do we go about it? What are the challenges and what are our responsibilities in the court of law? I request Dr. Niranjan to talk to us about this aspect. Over to you, Niranjan.
Thank you, sir. Very warm welcome to APAO 2025. And at the outset, I would like to thank the scientific committee and Nirmal sir for giving me an opportunity to be a part of this very unique instruction course. So here, today I'm standing before you to talk about the role of an ophthalmologist as an expert witness and its nuances. So anybody in this hall has been an expert witness in the court of law before, has had any experience at all? Because this is a very different ball game. So we come to conferences, we present, and we do have judges for free papers and, but this is completely different, mainly because just like we got used to some very new terminologies the moment we entered the field of ophthalmology, the medico-legal aspects, they themselves have a complete set of terminologies that we need to acquaint ourselves with. So in the previous two talks by Nirmal sir and Satyan sir, you would have come across certain terminologies, right? Like reasonable care and negligence, right? These are very much medico-legal terms that as an expert witness, we should be well versed with in order to be able to understand what the question is being shot at us in the court of law and to be able to reply aptly, right? So an ophthalmologist, like we discussed, is expected to be multidimensional, and as an expert witness needs to have adequate knowledge beyond the routine syllabus of ophthalmology. So as an expert witness, or I would say as a medico-legal cum medical expert, our role as an expert mainly can be broadly classified into these three categories of claims of compensation, claims of benefits in view of disability, and representing a scientific body to testify in case of negligence. So these are the usual scenarios where one would be expected to speak up in the court of law. So starting with the first one, that is the claim of compensation. So this is usually the scenario of having to encounter ocular injuries that happen at workplace, And as medical experts, we are expected to establish a causal relationship with the implicated injury. So whether the injury that has happened is directly because of the incident that is being incriminated. And also we are required to determine the severity of the injury, which is crucial for the degree of damage that has happened following the injury, right? So there was this article which spoke about the clinical profile of various medico-legal cases presenting to a tertiary eye care hospital in India. And among that, as you can see in the bottom of the screen, around 3% to 5% of the injuries tend to happen in the workplace that is a place which everybody visits on a daily basis. When we talk about injuries like road traffic accidents, yes, you can call them accidents, but these also are accidents which are happening at a place very commonly visited on a day-to-day basis. So what is the act that comes into picture is the Employee Compensation Act. So it is important to deem the percentage of loss of the earning capacity that the person has to suffer because of the injury that is being discussed. And as I've highlighted here, point number 4 is loss of sight to such an extent as to render the claimant unable to perform any work for which eyesight is essential. So this is where we come into the play, and we are expected to expertly opine on the percentage of loss of earning capacity after thorough evaluation. Then moving on to claims for disability benefits. So it is expected of us to evaluate the plaintiff and provide appropriate certification of disability as per the Government of India guidelines. And there is a concept of benchmark disability. This is very important for us to know, which is amounting up to 40% of disability, which is being provided with certain exclusive benefits and quotas for occupations in the government sector. So this is often beneficial to people who are having other challenges to face with in their daily life. So this is the Rights of Persons with Disabilities Act 2016, that is RPWD Act. And this speaks about two important areas which is of concern to us. One is the less common one, that is a physical disability, where there is difficulty due to loss of sensation and paresis in the eye and eyelid, but with no manifest deformity. And the second is the more commonly encountered one of visual impairment, where it has been broadly classified into blindness and low vision. So blindness refers to total absence of light or visual acuity less than 3/60 or less than 10/200 in Snellen's chart in the better eye with the best possible correction. Low vision, on the other hand, means visual acuity not exceeding 6/18 or less than 20/60 up to 3/60 or up to 10/200 in the better eye with the best possible correction. And not to forget the part of limitation of field of vision. Now one may have a relatively good vision in the center with 6/6 also, but limitation of field of vision too counts as disability, and that is explained as limitation of field of vision subtending an angle of less than 40 degrees up to 10 degrees. Okay, so these are two areas where the plaintiff has a claim, either as a compensation or as a disability. Now we move on to a whole new scenario where we are expected to testify in cases of medical negligence, right? So first is the scenario of where there is an alleged negligence by a colleague or a doctor who's incriminated during either the negligence having been conducted during evaluation or treatment. So the expectation from our side is to opine on the legitimacy of reasonable conduct. So this is what I was referring to you as terminologies, right? So whether a knowledgeable doctor would have acted in a similar way if being faced with a similar situation is what we need to opine on. So there are certain redressal commissions like Consumer Dispute Redressal Commission, and it is important to note that a significant proportion of the consumer complaints that are being lodged are related to ophthalmology as well, right? So the even more interesting part about this is about 73.3% of those which have been lodged have actually been successful in getting their claims, which means to say that we really need to work on being more medico-legally fit in order to avoid such cases. So this was mentioned very well in the article that I've cited here, increasing cases of litigation against ophthalmologists. So what are the qualifications that one must have in order to be an expert witness? First and foremost is to hold a valid current license to practice medicine and in specific ophthalmology. He or she shall not misrepresent his or her credentials, qualifications or experience, and also be knowledgeable about the standard of care with the latest scientific evidence. And how do you, perform as a proper witness in the court of law? First and foremost is reaching court on time. This is often understated because in our busy schedules, we may end up, creating a wrong impression, first impression with the court of law. Ask for the records of the case and try to spend some time studying it. Revisit the medical report that you have submitted from your side as a part of the evaluation process, and bring along an office staff from the court of law to the court of law if there is a remote location that we are talking about in the court of law. And also very important to tackle a lawyer and his interrogation. There could be intimidating questions from the lawyer, and it's essential for us to deal with it with calmness and composure, and we should not be very overwhelmed when we are disregarded or cross-questioned, because that's how the court of law works. And it's essential for us to be polite and, and to be expecting some amount of sarcasm and rudeness, because lawyers are quite capable of pulling it off. And lastly, during cross-examination, you may be expected to say yes or no only, but it is not wrong on your part to justify or take the liberty to explain or add what you want to say. Also intimate the judge if there is some amount of misinterpretation of your reports that you have submitted. And last but not the least, refrain from opining beyond your area of expertise. So what is the groundwork to do to be a good expert witness? Make sure you maintain good clinical records, medico-legal records of treatment done before the patient visits you and while in your care. And this helps in establishing continuity of treatment. Documentation to be recorded systematically, and remember that the facts are in the details. So do not miss out on the intricate details of examination while you're examining the person in question. Legible handwriting, specific findings in the right terminologies, and try to include more diagrams. Even simple line diagram speaks a lot in the court of law, because that shows that you have taken enough efforts to document what you're seeing. And certain advocacy measures which may be beneficial are to include a separate section in the syllabus of post-graduation about these medico-legal aspects, as there is very little knowledge imparted to us in our undergraduation in the subject of forensic medicine. And lastly, having bridging instruction courses like these in conferences to fill the gaps of lack of knowledge or lacunae of knowledge in these arenas. So the take-home message, both the right skill set and mindset are two prongs of an expert witness. Knowing beyond your subject is good, but try to stay within your field. Beware of your do's and don'ts in the court of law. Meticulous background work in your workplace is mandatory to perform on the D-Day. And lastly, keep updating yourself with recent advances. Thank you.
Thank you, Niranjan. That's perfectly on time, and thank you for the wonderful talk. And now I invite Dr. Murli Ariga to talk to us and tell us on how to anticipate risk in ophthalmology and how to manage them. So risk assessment and preparation for the risk is essential to avoid or prevent the risk. So over to you, Murli, for telling us about the medico-legal risk in ophthalmology.
Thank you, Dr. Nirmal. And at the outset, I would like to state that this is an awareness talk, and the examples I quote are not intended to target any individual or institution. And the first and foremost we have to understand about the law and health is that the right to health is recognized as a fundamental right in Article 21 of the Constitution. So therefore, this is various acts, Constitution, the acts of Parliament, legislation, pronouncement of the case laws, international laws, and WHO. So health is considered to be a fundamental right. So the state has the right to frame laws, and we have to abide by them. That's the first thing. So we are dealing with health, ophthalmology or otherwise. So health is the most important part of a fundamental right. So you don't have much say about what the government decides and what is the law. So first and foremost about the health and the law is that this question came up recently about, can we choose a patient for treatment? You are sitting in your practice and the patient walks into your clinic. So can you accept a patient for treatment? Can you provide the treatment? You complete the treatment. Do you have a choice of not accepting? Can you refuse a particular patient? Yes, you can refuse a patient for treatment, provided it is not an emergency. But in emergency, you have to accept all patients for treatment. So this emergency is actually a gray area. Our societies, for example, our state society or the national society, we have not decided what is an emergency. Is acute headache an emergency? Acute glaucoma an emergency? Foreign body in the cornea is it an emergency? Vitreous hemorrhage is an emergency. Vitreous hemorrhage of 3 months is an emergency. So we have not actually defined what is an emergency. Therefore, a lot of gray areas are there. So we are bound by law to treat any emergency, whatever is considered to be an emergency in the public eye, in the best of your ability, to the best of your ability, good faith, reasonable care, a prompt referral if you don't specialize in that, without any monetary consideration. That's the catch. So everybody expects us that we are all millionaires, we're all earning, minting by the minute. So therefore, we need to provide treatment as an emergency. This, I think you must have all seen this scary news about right to health. Anybody can walk into any practice and say, I have a headache for 6 months. I have an acute emergency now. You see me right away. Private hospitals, government and private hospitals have to do that. So that is the problem with the. So luckily, this was rolled back and is not brought into a national level. So right to health in private practice. The government has institutions. The government can take care of all emergencies. Where is our subsidy? Where is our sort of incentive to do free work for emergency cases? We can probably provide first aid, but not really start the full-fledged treatment for any kind of emergency. So I think Dr. Nirmal had mentioned about how our profession is regulated. We are heavily regulated. We have lots of laws, lots of things which we had to abide by. Previously, it was the MCI. Now it is the National Medical Commission. And we have various boards under that, especially the Ethics and Medical Registration Board, which is now slowly coming in, and we all have to abide by the rules. And of course, the current ethical regulations, what we have to follow is the Professional Conduct, Etiquette and Ethics of the 2002. It has been amended several times. Recent amendment has been in 2016, 2017, 2019. So I think all of us have to go through some of the aspects of the ethics and code. And this is the what is currently just a very brief summary of what is all of us when you sign our Hippocratic oath. This is what we actually sign for, about the ethics, about duty of physicians to our patients, to physicians to each other, physicians to the public and the paramedical profession, and we should not be indulging in unethical acts and misconducts like advertisements, media, going in. A registered medical practitioner cannot go in and solicit patients, whereas a hospital or a corporate can do so. So a registered medical practitioner should not accept gifts of a certain quantum of money, and certain receive commissions, cutbacks, employers fee splitting, employing touts, and not compelling patients and doing what is called a tide selling. All kinds of acts and laws are available. So we should understand various aspects of how we practice. So we understand that suddenly we realize that we have done something which is now coming under an act which of Parliament in which we should not have done that. And the ethics committee as well as the the rules and the guidelines now tell us that medical records slowly we have to move towards, or if you have not done so already, please move towards digital records, electronic health records. And all physicians must maintain copies of the records of all inpatient records for at least 3 years. That's the current regulation now. Certain states, certain hospital protocols may vary, but the minimum absolute is 3 years. 3 years, 5 years, 10 years, we like to keep it for all of the records of however long you've been practiced. That is good. So try to digitize, try to keep it electronic, try to maintain all records. The CEA actually has specified that. And anybody who asks you for any kind of a summary or a record of what treatment you have provided to somebody, the treatment you must provide within 72 hours. That's the current regulation. And also, we all know that currently most of us, hospitals, clinics, we are all regulated by the Right to Information Act. Somebody can write to you under the Information Act and ask for demand for information from your hospital as to what is going on in your institution. So the RTA is now applicable to hospitals as well. It's not just only private clinics and everything else. And all of our labs, all of our primary healthcare, hospitals, pharmacies, everything better to go in for digitization. I think we must avoid, as colleagues and among our, we see, can anything be made out of this? So we all like smile, say a doctor's handwriting, and we all say that this is the way it should be. So but we really have to move beyond this, and we should correct ourselves and correct our own colleagues and ourselves, make it legible, make it right in hand. And also the prescription of writing generics. So the government is coming down heavily on us because of this reason, that we should prescribe and write only generic medication. There are limitations because there's a huge cost difference between what is generic and what can be a branded medicine. So there is an out-of-pocket expenditure for the patient, and I think we are justified in probably to an extent, large extent, recognizing a patient's inability to pay for something and then prescribe a generic if possible. I think you're all aware of government opening up these pharmacies all over the country now, where they sell only generics. So the professional conduct review, this is a recent publication, a press release from the National Medical Commission. I'm not sure all of you have seen this. This is a very important document. You must see some examples, case examples. I'm going to quote a few examples from this. The professional conduct review has shown about 10 examples of what have been litigation, what has come out as outcomes in the consumer forum, and what we can learn from them. I'll give you one example from the same professional review publication. Dr. R was practicing as a consultant sonologist with a 6-month training certificate according to the PCP Act. What happened is he started performing ultrasound for other illnesses beyond the scope of his certificate under the PCP Act. The local IMA took cognizance and filed a complaint. After deliberation, they removed his name from the state medical register for 2 months and asked him to refrain from practicing as a so-called consultant sonologist. He was practicing as a radiologist sonologist with a 6-month certificate under the PCP Act. And then despite this order from the State Medical Council, he continued to perform ultrasound for other indications beyond his training and still use the word consultant sonologist. So he appealed against this in the Honorable High Court, and then which they reacted to the National Medical Commission, which again pronounced his verdict and said that you have to give an undertaking that you should not practice beyond what you have been qualified for, and do not use the term consultant sonologist. It confuses the public. You have only undergone training just for this particular act alone for 6 months. You cannot become an and then similarly another example of what we should do and what we should. I think I have time for 15 minutes. I think timer is set wrong. The ethical regulations specify that a physician should not claim to be a specialist unless he has a special qualification in that branch, according to our professional conduct, the 2002 regulations. So therefore, we cannot practice beyond your specialty. You cannot practice cardiology, you cannot practice obstetrics and gynecology. Maybe you can treat an emergency and immediately refer out to somebody. Don't profess or don't claim to be a specialist in what you don't have any training for. For example, if you are a cornea specialist, you must have had some subspecialty training, some proficiency in that particular specialty. And do not affix signboards on chemist shops. Do not put in places where you don't work. You can't put up names and signboards in those kind of places. So this is another example of a urologist who treated, this is again from the Professional Review Board examples. This is where the case went through. Patient had a ureteric stone. The stone was removed by a qualified urologist, and his associate gave a discharge summary which did not specify which method of surgery was done. And the surgery, when he went to another doctor, they found the stone was still there. So they claimed that the stone persisted, and this PCNL and this RARS was done. The consent was taken for the same, but the summary did not mention what procedure was done, and the junior colleague did not document it in the medical records. So there was a discrepancy between the procedure done, the operation notes, the statement given in the online hearing, and therefore his name was removed from the register. This is a fact. This is what has happened. Even though you're a qualified urologist, you've done the procedure, this kind of discrepancy was there in the operation notes, and the statement given, the discharge summary did not mention what was done. So what was stated, what was in your notes, and what is in your discharge summary has to correlate. And it can be your associate. Your associates are also liable under you. So they become vicariously liable. All your staff are vicariously liable. You are the boss. Suppose you are the person who is the main surgeon. Whoever makes a mistake and works under you, you have to take responsibility for that as well. So document the communication and communicate the documentation. So the doctor did not document the procedure. There was inadequate communication as to what was actually done. There was a discrepancy, clear discrepancy as what was done and what was given to the patient. And do not make negative statements. One doctor who saw the patient subsequently has made very adverse negative comments about the previous surgery, saying that the stone is still there. Has he removed it at all? I can still see the stone there, and so on. These kind of negative comments to patients about clinical judgments and the procedures by other colleagues, and therefore we need to have trust in each other. We need to have belief in each other. We have to hold hands. We are a fraternity. We have to hold hands and do not demean another professional. What exactly went on in the other hospital, nobody really knows. He could actually prove that he had actually done the procedure and he had actually removed the stone, but it could not be proven with the documents available. So that's the problem. The CA, I think Dr. Nirmal has mentioned about the need for CA, and primarily this is actually a crackdown on quackery, so we really need to appreciate the government's efforts to bring in the CA, so only qualified professionals can actually practice. But what is important about the CA is the treatment guidelines. You look at the website of the CA, you will find there are treatment guidelines even for ophthalmology. For so many subspecialties in ophthalmology, also like cataract, glaucoma, retina procedures and all that, certain guidelines are available. You have to abide by the guidelines. For example, if they say a blood sugar of 200 or less has to be kept in place for your cataract surgery, you must follow that. So these guidelines are important because these are more used by our advocates and the legal professionals who look at these guidelines and say you didn't follow that. We actually don't look at much of these guidelines. So consent, I think Satyan had pointed out about the various aspects of consent, the implied consent, the express consent, the doctor's liability. Suppose you do a procedure without a patient's consent, you are actually liable under civil law for tort law for battery. You have assaulted the patient without the patient's consent. And for suppose you have done something which is endangering the life and caused some grievous hurt, some complications happen, you are liable for criminal negligence. So therefore, consent is a very important aspect. You must, I think he quoted this example, a very famous case of a consent given for a specific procedure about not being valid for something else. You have taken a consent, express consent for one particular procedure, and suddenly you decide to change it on the table and you go back and inform the patient or the relative after the procedure, it is not valid unless it's a medical emergency or a life-threatening emergency. Do not do it. Suppose you need to stop, you stop operating, go back, get the consent, come back another day and operate. Don't do procedures which you think is good for the patient in good faith, in your own opinion, you feel the second procedure should be done. Don't do that. Always stick to guidelines. For example, this is an example of maybe a few years ago, we had a patient who underwent a YAG PI and went in for a total hyphema, corneal decompensation, raised IOP, went in for a legal notice and then is still in court. But the consent did not include bleeding can happen after YAG PI. How many of us take consent about YAG PI? How many of us inform the patient the bleeding can occur? It can be 1 in 1,000. But if this happens to your patients, what can happen? So we make sure that everything is like he mentioned in the consent. Mention all the possibilities, all the common possibilities, what can happen. Explain to the patient what are the alternatives and what are the, suppose you don't do a YAG PI, what can happen to a patient. So make sure you explain all of this, the alternatives, not doing it, consequences, and complications. For some reason, the patient is not willing to sign the consent, do not do the procedure. Simple as that. Don't push yourself and say, this is good for you, I'm going to do it for you. Don't do that. Stay safe. Consumer Protection Act, I think the VP Shanta case is the landmark case. There was an amendment in 2019 which said that the medical services, somebody misinterpreted that medical services would be removed from the ambit of the CPA. It is not true. Medical services do remain under the ambit of the CPA. Even the recent Supreme Court has come out heavily and said that the doctors will remain under the CPA. We continue to remain liable under the CPA for medical negligence. So medical negligence, you have civil and criminal. Criminal is what we all sort of concerned about. Suddenly some complication occurs. Even at endophthalmitis after cataract surgery, people go to the nearest police station and say there was negligence. So a complication is not negligence. A complication is not criminal negligence. A doctor is held negligent only when his or her treatment is not in line with, he was pointing out about reasonable standard of care. What you have done is following standard of care. What is you have done is result in a legal injury and there has been some damage done to the patient. So only then you are negligent. Only then if you are criminally negligent, where the negligence has to be of a gross nature, really gross nature. That's when it becomes a criminal negligence. Don't worry about criminal negligence. Most of what we do is routine stuff. Most of complications we face is not negligence. So you have to understand, but however we are liable, suppose somebody wants to dispute what you have done, they can go to civil court and the consumer forum is the most convenient for everybody. So this is an example, I think, of a doctor committing suicide because of a complication of a gynec obstetric procedure. And what has happened is, and this was actually a lot of hue and cry about this, because the police station took cognizance of a complication of a gynec surgery and went in and tried to arrest the doctor. The doctor committed suicide. So basically, it was just a complication of surgery. The police had no business to file a FIR. This was in Rajasthan, and the Rajasthan police had booked a FIR. But this is true negligence. True negligence is when you're screening for ROP, and if you missed it in the first month, 2 months, 3 months, and the baby loses vision, temperature normal, pulse normal, but what about the eyesight? Have you checked the baby's fundus? So this is a very important aspect. I think Satyan also pointed out about huge compensations are given because the child is very small. The compensations can be huge if you miss it. So make sure you follow the protocols for screening in these kind of diseases. Don't make mistakes. And this is a very common news item we will see about botched eye surgery. This is a newspaper's famous headlines. Everywhere you will see something happens as a complication, cataract surgery in camps, botched eye surgery. But sometimes there can be gross negligence, like one hospital discovered in this case in Trichy, about a large number of patients who lost vision, and running the hospital without taking legal consent from the pollution board. Improper design of the operation room, no separate room for sterilization. The CBI was involved in this. CBI got involved, people who are held criminally negligent, and a huge amount of fine was imposed. There was no appointment of an anesthetist here. The hospital is functioning without a lab for those particular camps, and the common things were not checked. No staff for sterilization. The infection was not reported. All kinds of things went wrong with that particular situation. Therefore, we really don't have defense if you're not following these kind of guidelines. So follow the NPCB guidelines. If you are doing camps, if you are doing cataract surgery in camps, make sure you follow the NPCB guidelines. Stick to the protocol. This is an Arvind model, is a fantastic model of how you maintain quality in community eye care. So follow these guidelines and don't cross the line. Exceptions, confidentiality, I think I'll skip this. I think just an example of, we all assume that you can do an HIV testing for cataract surgery. How many of you do HIV testing for cataract surgery pre-op? Most of us do. So what we do you know under the law that you have to disclose to the patient that you are testing for HIV? You must take consent from the patient before you test. All kinds of guidelines you have to follow. So make sure you understand the law before you go through that. And this is an example of a case in which patient was given a intravitreal injection and had a vitreous hemorrhage following a very casual Avastin injection was given. The patient has complained in court. The doctor was engrossed in conversation during the injection. He was making a casual comment talking about some news or cricket or some business, and the compensation was 1 lakh. So purely because there was a vitreous hemorrhage and a casual conversation was there. This was done in the newspaper. Not even in a, this has been public, now the doctor has been held up because of this particular complication. So I think this is also clear that what is, this need not have any explanation at all. You leave behind bits like this. This is particularly for my specialty of glaucoma, where we leave behind small bits of mitomycin swabs, like how you leave behind like this. The thing speaks for itself. You don't have to say anything. This is gross negligence. You can't do that. So I think he mentioned about the NCRD's 942 cases, the National Consumer Forum. This was published. 942 cases of medical negligence decided by the NCDRC, and of these 30 were related to ophthalmology. 73% of the alleged cases of negligence, it was proved, and the compensation ranged between 2 lakhs and 10 million. So be aware that ophthalmology is serious business, and the maximum number of cases, by the way, was from Delhi. The recent laws, we have to understand many laws, many laws. Now I think Mr. Nirmal was pointing out the Telemedicine Act, the PCPND Act. During COVID, what happened was a lot of laws were there. This also we have to understand there's a lot of violence against our healthcare professionals and our workers who work with us, even our nurses and paramedics. And all of this is considered to be violence. It's not just physical violence. The main thing we find is a trust deficit, the lack of communication. The cost is a big problem. Suppose we state some particular amount for the procedure and the cost escalates. This is where most of the arguments come. Cost escalation is a big thing, so make sure you handle that properly. Crowding, congestion, overburden, lack of communication is on top of the list. So this is the primary thing. Many of the laws dealing with healthcare workers, there is no specific national law for doctors. Understand that there's an ordinance passed, there's a bill that fell through. Only certain states have some Medicare prevention of violence. Tamil Nadu has one, many other states have. So state-specific laws are available, there is no national law. So most of our advocate friends and lawyers would tell us, avoid the circumstances that lead to the violence, and deterring such acts is very important. So put up boards like this in your practice. Say you're on camera. Be aware that we do not tolerate these kind of violent acts. So make sure you take steps to deter the violence. Handling the violence after it has occurred is very difficult, and you really get the compensation which you get is pittance compared to what loss has actually happened. So make sure you avoid the circumstances, take deterrence. And of course, this is very important, take indemnity insurance. Malpractice insurance will be a safety net to help you in the lawsuits. I think the IMA PPLS, I think Sendil will talk to us about the IMA PPLS schemes and about the AIOS2025 which has now come in. And ensure adequate coverage for your specialty and the practice size, and review your policies periodically. So document everything, communicate well, have checklists and protocols like the NABH protocol. It's very, very important to be safe in practice. Do not step out of your guidelines. Keep the ethical practice. Stay united as a fraternity, and make sure you are part of membership of your local organizations. And they have, all of them have legal cells. Like we have one in Tamil Nadu, we have one for the national AIOS as well. Take help from the legal cell, and don't sidestep, and don't think that, okay, I think you all understand what this means. Nirmal also pointed out this. Ignorance of the law is no excuse. Think that I don't know about some act or something in what has already been established by law. You don't understand that is no excuse for you to practice. You have to understand the law. We need to understand under the, what we work under. Thank you all.
Thank you, Murli. It was a lot of very informative insights about the legal risk. I'm sure it would be useful to all our delegates. Now I invite Dr. Senthil Kumar to talk to us about the lessons learned from legal cases. So, as I said earlier, he's been the chairman of the PPLSS scheme, which has been very successful in defending the number of negligence cases in Tamil Nadu. Over to you, Senthil.
Good morning. I would like to thank AIOS and Dr. Nirmal sir for giving me this opportunity. So, this presentation is going to be a summary of what the previous speakers have dealt with. So, without doubt, those were very excellent speeches, and there will be some areas where there will be a lot of crossing overs, just to stress the importance. So, don't mind much about the crossing over areas. So, legal case, it's a dispute between parties resolved by court or other legal process. So, it's a party who feels wrong or has a claim against the other party initiates a process by filing a lawsuit. So, Dr. Murli had already touched upon this thing. Civil lawsuits could be due to breach of contract, civil wrong, that is tort, product liability, so we need to keep that in mind also, consumer litigations. Criminal lawsuits are, it happens when there is a violation of law and prosecuted by the state, which results in imprisonment or fine or both. Sir has given an example of that Trichy case where 2 doctors were sent for imprisonment for a period of 2 years. So, case law, this is more important because these are based on the judicial decisions. Similar case, when a judgment is given by a Supreme Court, that has a binding value on all the courts of India. And accordingly, a judgment given by a High Court has a binding value on all the courts of that particular state. So, legal cases in ophthalmology are due to medical negligence, inappropriate diagnosis, improper communication, inadequate or improper consent, inadequate documentation. Most of these were dealt in detail by the previous speakers. So, common cases in ophthalmology were related to cataract surgeries, corneal surgeries, retina surgeries and ROP screening, squint surgery and insurance related cases. So, like it was pointed out, 3% of the cases in the past 20 years were from ophthalmology, and we need to be mindful that the compensation rates were really higher. That's more important. And that 942 cases were the cases which are filed in the court. Apart from that, there were advocate notices also. The difference is, advocate notice means when you receive an advocate notice, the reply can be given by yourself or on behalf of you, a medico-legal consultant, but it should be like as if you are writing the reply, or a lawyer can give a reply. But for a court notice, the reply has to be from a practicing lawyer only. So, these notices were common even with when glass prescriptions were not given to the patient in the OPD after consultation, there were advocate notices and notices given that you had not informed me that there will be a photophobia following a dilatation, so I had met with an RTA. So this is the place where your general consent has an important role. So while getting an general consent, tell that in case if needed you will be dilated, and after dilatation there will be a photophobia for around 4 hours and related to that. And while giving prescription, in the prescription there should be a comment on, if there is a steroid, there should be a comment that it should not be used for a longer time. There were cases related to that. A 4-year child was given an steroid treatment, was continuing the treatment till 18 years, landed up with optic atrophy. And a comment should be there in anti-glaucoma medication that it has to be continued lifetime unless informed by the surgeon otherwise. So let us see some case studies. Cataract surgeries and related complication when there is an unexpected visual outcome. Nucleus drop and referral to retina surgeon, PRP laser and field of vision. Squint surgery leading to death of patient. Squint surgery where bilateral lateral rectus recession was done, resulting in an complication of esotropia. We will get into these cases. So insurance related cases were mostly like wrong diagnosis entered in discharge summary. For example, for LASIK surgery, if you want the insurance approval, the dioptric power has to be more than 6. There we know that to benefit the patient, we will write that refractive error of 7 diopters or so. But in case if something goes wrong, the patient will tell that all my previous prescriptions, the refractive error is around 2 or 2.5. The doctor, in order to mint more money, has given an false diagnosis. You cannot come out of that. So then split up charges. We all know that you will be giving an split up charge for around 40,000 or so, but insurance company will only approve somewhere around 22,000. So the rest 18,000 will be collected as cash or through GPay or other means. What will you do in case if the patient asks for a bill? Insurance company won't allow giving an excess bill, because like he might claim that with that bill what you are giving, he might claim. So insurance company won't allow giving a bill. So in that cases, what we can do is give a bill stating that towards other expenses apart from insurance approval. Or in ophthalmology, we can also do something like bill towards a glass prescription. In case if 18,000 is the excess value collected, you can inform the patient, I cannot give a bill as per insurance. So for you, towards income tax purposes, I will give a bill towards optical expense. That's one option I am giving. So this is an squint surgery where the child was admitted in hospital for squint surgery. Bilateral lateral rectus recession was done with a resultant esotropia causing diplopia. The patient went to another hospital, underwent another surgery, then filed a case against the first hospital that there was negligence. So the case went on, and the doctors could successfully defend, stating that we had advised Prism for correcting diplopia. The patient has not followed our advice, and without our knowledge, he underwent surgery elsewhere. So the point to be noted in this is mentioning the review or follow-up is very important. So we can tell that on this particular date, I had advised the patient to follow up after so and so time. Patient has not followed up. So there is a contributory negligence. So nucleus drop and referral to retina surgeon. This is one common scenario what we see. So there was a cataract surgery, nucleus drop was there, and the patient was referred to a retina surgeon. So after 4 months, patient files case against the first surgeon and the retina surgeon, stating that his visual outcome was not as expected and is under treatment elsewhere constantly for the past 4 months or 5 months. So this case could be defended because like nuclear stop is one of the common complication. Following a complication, the doctor has done his level best and referral is not a negligence. So the patient has not followed the advice of retina surgeon after surgery, in the sense he has not followed with the retinal surgeon where he got operated. The thing to be noted here is the documentation of the first surgeon and the second surgeon was differing a bit. So that's where we get into trouble. So like Dr. Murli said, you need to document the communication and the communication needs to be documented. So whatever the first surgeon has said, in case if the first surgeon has documented, like pieces of cortical material were found in the vitreous, then you can write, instead of writing that if you want to protect the other surgeon, instead of writing the whole nucleus is in the vitreous, instead you can write material of around 7 mm is found floating in the vitreous. Means we know that the nucleus is only going to be of around 7 mm. Sometimes it will be helpful for us while defending the case. So like it was mentioned earlier, the communication has to be properly documented and a separate consent in case if we are going for the second surgery, which should mention the risk, benefit and alternatives. PRP laser and field of vision loss. There is a case where the patient has made a litigation that he was not informed. Sir, can I take 2 more minutes, sir?
Yeah, please go ahead.
So he was not informed that there will be an restriction in the field of vision. So this case actually got dismissed, and in the due course the patient also died. So that was one way helpful actually with regard to that case. Yeah, no sir, like few cases the patient has to be there. Here we could state that the patient had so much of complications, and because of the complication the patient has died, leading to other general thing also. So such is the disease burden. Okay. So one more case, there is a squint surgery where the compensation was in the tune of 1 crore. 6-year-old child was admitted for squint surgery and the child died during the procedure. Hospital, anesthetist and surgeon were directed to pay compensation around 1 crore rupees. So here the cause of death was hypoglycemia and shock related. National Consumer Dispute Redressal has mentioned in the judgment that the negligence was proved due to the following reasons. The fasting time and the last oral intake to the commencement of surgery was higher, somewhere around 9 hours. There was no coordination between the anesthetist and surgeon regarding to adverse drug events, halothane and scoline. Fitness was not given after undergoing necessary investigations, in the sense, initial doctor who had seen this kid has told that there is a murmur, but subsequently another cardiologist has told there is no murmur, so fitness was given. And previous speaker has mentioned that whenever they ask for a document, it has to be given within 72 hours. In this particular case, the hospital has taken more than 6 months to give the case sheet documents. And it was also mentioned that in the discharge summary, the events of CPR were not recorded. On top of it, always there will be an emotional aspect during judgment. So here that's a precious child since the mother underwent hysterectomy. So medical negligence is, there are 3 components. There should be a duty, breach of duty and resulting damage. So resulting damage, I am talking about the resulting damage. Unfavorable outcome doesn't mean negligence always. So that is informed in a lot of judgments, landmark judgments. So to indicate negligence, there should be material available on record. So not possessed with reasonable skills which he professed to have possessed, or did not exercise with reasonable competence. So why I am mentioning that is, so I will come in the later slide. The lessons learned from litigations were documentation, need for documentation, proper communication, proper consent. So cataract surgery, B scan should be done in mature cataract. There was a case where the compensation was given because the doctor has not done an B scan. Always remember, discharge summary needs to be countersigned by the patient and attenders, telling that we had taken a discharge summary. So why I was telling about not possessed with reasonable skills which he professed to have possessed, or because like Murli sir was talking about that particular case of sonologist, trained sonologist, that he was trained for 6 months and then he is claiming him to be as a radiologist with MCH degree creeping up in ophthalmology and DNB super specialty courses in retina and other specialties. How courts are going to interpret the skills obtained in fellowships program? This is a question to ponder. And last few slides. So whether CAM surgeries are a thing of the past or it is coming in a different format, hospital on wheel concept. So there are several unanswered questions for a hospital on wheel concept, like obtaining various mandatory license like PCB license, CA certificate, biomedical waste, how they are disposing the waste, sewage treatment, sanitation certificate, etc. In case if some of the patients who is not getting the expected visual outcome goes into a court, will be in trouble. So way forward is following government rules and regulations, adherence to policies, quality of work, focusing on the quality of work, documentation and accreditation. So I have taken one last slide to stress the importance of any accreditation process, be NABH or other things. The case where I said the compensation was around 1 crore, there were few lines in the judgment which are mentioned about the pre-medications which were not discussed between the doctor and the surgeon and the anesthetist, and the OT list which was higher, it was around somewhere around 16 cases in that particular day, but the patient, that kid was kept on fasting for around 9 hours, not mindful of the fact that this hypoglycemia can also be an cause for shock. So it's very surprising to see that whether the judgment was given after going through this objective element. So nicely this objective elements was framed, thanks to Dr. Nirmal Frederick sir, was nicely framed these objective elements. So I'll just read out that depending on the pre-anesthesia, a plan for anesthesia should be documented. The plan should mention the pre-medications, type of anesthesia, special requirements, anticipated post-anesthesia care where appropriate. This was mentioned in the judgment. The preparation for patient by OT staff are based on the plan of anesthesia signed by the anesthetist. It is also documented in the OT list. So these were the things which are exactly mentioned in the judgment. So as to conclude negligence, and the objective element of COP 3C, COP is care of patient 3C, mentioned that the events of CPR should be documented. So again, this particular point was mentioned in the judgment, that the events of CPR were not documented in the discharge summary. So going for accreditation is not for getting the piece of paper that so-and-so center is aggregated, but for improving the quality, and it has to be a journey. Thank you.
Thank you, Sandil. We have some time for questions, 5 minutes. We have any questions from the audience? Yeah, please come to the...
How long we have to keep a record of ROP screening?
Sorry, come again. How long?
How long we have to keep record of ROP screening?
Okay, so the... Yeah, Satyan, you want to know? Up to 18 years, till the child becomes a major, we need to maintain it.
Documents your case sheets, sir.
Patients, yes.
Case sheets you have to keep it for 3 years.
No, he's a child.
How long it has to be, the child has to be screened?
He came for first ROP screening at the age of 3.5 months. Twin children, and both are detected with total RD. So I'm asking for how long we should keep that record.
Okay, so I'll just clarify this. If you are treating a pediatric patient on outpatient basis, you need to keep it for 3 years. If you are performing any procedure, treating as an inpatient and follow-up, you need to keep the records as per the DGHS norms for 6 years. And for any child, if you are doing a procedure, you need to keep the records till 18 years, till the child becomes a major.
No, sir. I will speak in Hindi. I will explain better. 3.5 महीने का बच्चे 2 ट्विंस आरओपी स्क्रीनिंग के लिए हमारे रेटिनल सर्जन ने आरओपी स्क्रीन की और वो टोटल आरडी डिटेक्ट किया हमको। उन्होंने हमको रेफर कर दिया एम्स के लिए। पेशेंट कहीं और एडमिट था पीडियाट्रिशियन के पास और वो जब से 3.5 मंथ जब से डिलीवरी हुई तब से एडमिट ही थे वहाँ पे। तो ये केस तो बाद में कभी भी जाके कभी भी पीडियाट्रिशियन पे फाइल होगा और उस टाइम फिर जब ज़रूरत पड़ेगी तो हमारे रेटिनल सर्जन का भी रिकॉर्ड चाहिएगा। अब वो कब ज़रूरत पड़ेगी, बच्चा बड़ा होगा, कब केस फाइल करेगा या नहीं करेगा, तो वो तो लाइफ लॉन्ग के लिए ही रखना पड़ेगा रिकॉर्ड।
नहीं, ये जो बच्चे का जो केस रिपोर्ट्स है, तो ये रिपोर्ट्स है लाइक डॉक्टर निर्मल मेंशन 18 years इज मैंडेटरी इफ इज अ चाइल्ड एंड देयर इज अ पोटेंशियल लिटिगेशन इन्वॉल्व। सपोज कोर्ट का जो केस हो गया, किसी ने इसको कंप्लेंट दिया कि नोटिस आया, तो तब तो जब तक नोटिस चल रहा है, कोर्ट में चल रहा है, केस चल रहा है, तब तक इट हैज़ टू बी मेंटेन। सो 18 years
केस नहीं चल रहा है।
नहीं,
और
यू कैन
18 years
एक्सपेक्ट
तक अगर कोई केस नहीं हुआ और अगर बाद में हुआ तो
हो सकता है पोटेंशियल लिटिगेंट। सो यू बेटर टू कीप रिकॉर्ड्स टिल 18 years of age, till child is 18. If there is no
18
litigation,
के बाद अगर केस हुआ तो
उसके बाद हुआ तो भी I see ideally depending on your hospital protocol how long you keep. Each hospital has its own protocols for keeping records. Some of us keep for 20, some of us keep for 30, some of us even digitize and keep it forever.
लो अगर 18 years तक रखना मैंडेटरी हो।
Absolutely mandatory is 18 years.
अच्छा।
इस
उसके बाद
सिचुएशन
अगर रिकॉर्ड नहीं है तो
सपोज
we are
कोर्ट
not
में
going to-
नोटिस आया लो,
डॉक्यूमेंट स्कैन कर आपको रख दो।
So legally, you need to keep the document up to 18 years of age. Okay. See, after 18 years, to be safer, as per your hospital policy, if you are going to condemn it, just you need to give an advertisement in local papers telling that you are going to condemn the case sheets from this date to this date. If any patients who are interested can come up and take up the case sheets, or beyond this date we will be condemning this case sheets. So in case if the patient comes and takes the case sheet, you need to get a document that I had received the case sheet on this date. You keep the document with you. Or if you think that patient will go for litigation in the later part, either we can keep the document in your MLC cupboard, or if you want, you can even hand over the case sheet to the patient after getting that signature from the patient that they had received the case sheet. So once you had condemned, court cannot ask for the document. But before condemning the document, you need to advertise in newspaper. That's mandatory.
Thank you, sir.
Okay. Thank you. One last question. We need to close the session.
Sir, for a routine macho cataract surgery, I advise patient for B scan. Since the B scan is not available at my hospital, I advise him to go other hospital. Then he has to pay some charges. Since the patient is very financially, he is not very sound and he cannot afford a B scan somewhere else. So sir, in that particular case, should I go without the B scan done, or should I still inform the artificial prognosis and do the surgery?
Yeah, you can advise the patient, give it in writing that you need to take a B scan. If the patient is not willing to do, so get that documented. That patient is not willing to perform B scan because of the financial issues.
But sir, since this is a routine surgery, it is not an emergency surgery, and I'm still doing it without the B scan. So will I be held liable? If
You will be liable
You will be-
because it is under the standard of care. But once you tell the patient that it has to be done, and if the patient has not followed your advice, so the onus is on the patient to prove that he is not accepting your advice.
so I did the surgery, so I'll be safe.
Mention the
Yes.
same in consent. write that I had advised for a B scan and I am not willing to get this B scan done for whatever reasons. I understand that there is a risk of not getting that post-operative vision as expected in case if there were to be some posterior segment complication.
So in this particular case, I asked the patient to write in a paper, and I also
Not in the along with the consent you can
Along with the
continue.
consent.
Okay. And sir, one more thing. You mentioned, sir, consent for HIV testing. Sir, I didn't got that point.
No, obtaining a consent for testing for HIV. You cannot do HIV test, you cannot do a routine blood sample without informing the patient that you're going to look for HIV.
So in particular HIV or sir, any other?
In HIV, under the HIV Act, you have to obtain consent from the patient for drawing a sample and testing for HIV. You're doing a blood sample and you test for HIV without the patient knowing it, then you are liable.
Then I'm liable.
So these are enunciated in the NACO guidelines, patient privacy issues. So if you have to test for HIV, you need to get the consent, counseling and then consent.
Yes.
So similarly, there was one case where patient underwent a renal transplant and the hospital gave a TT injection prior to cataract surgery, and attenders were very anxious about having a TT injection to a post-transplant renal transplant patient. But nephrologist says it's a dead virus and it doesn't cause any rejection, but still you have to inform any patient, whether it is HIV, hepatitis B, C, TT injection, test dose, everything, you need to inform, only then you need to perform.
So one patient came to my OPD with a road RTA accident. There, sir, he came directly to me. He didn't know went to the surgeon or a physician. So in that particular case, I told the patient verbally, and I also written in the referral notes that you have to get out tetanus injection with the other hospital, because I didn't have it available at my hospital.
Okay,
So
I
I
think
did-
we are exceeding time. So let's close the session. We can, yeah.
Sir, I'm working in a government hospital in Uttar Pradesh. There we don't have B-scan in our hospital, but we are operating a lot of patients there. Regarding the AIOS guidelines, the patient with comorbidities has to be seen by the physician or consult specialist. But the B-scan guideline is not there. The AIOS guidelines.
No, the AIOS guideline can mention only the standard cases. For your own protection, for patient with mature cataract, B scan is necessary to protect yourself. So in case they have a posterior segment complication and patient claims that I was not told about B scan, so then you are in a trouble. So to safeguard ourselves,
In most of the government sectors.
yeah, we understand, but if it is not available also, it's your duty to protect yourself. Tell the patient that this can be done for your safety.
AIOS booklet on legal aspects, which was, I don't know when it was released, that mentions that you need to have a B scan prior to surgery in case of a mature cataract. AIOS legal aspect booklet, which has specified that not having a B scan for a mature cataract is an offense.
See, doing something in good faith, in the best interest of the patient, all those things are all legal jargon which you can use for saying you did something without doing a B scan. But for your own safety and protection, just ensure that somehow the B scan is done, even waive off the charges, they refer it to a government hospital for a B scan. Just ensure it is done for peace of mind for all concerned.
Actually, most of the patients we are getting mature cataracts only, in which the fundus cannot be seen.
Then you have to buy a B scan.
Buy a B scan.
One question is here. Is anesthetic is essential for cataracts and anesthetic?
Anesthesia, anesthetist.
Anesthetist or anesthesia?
Anesthetist.
An anesthetist is, I think, Dr. Nirmal also answer that. It is not mandatory to have an anesthetist for all local anesthesia procedures unless the patient has a cardiac risk or your health risk has been decided by you, or when you find that you need an extra care. But in general practice, suppose you have a busy institution with all dealing with elderly patients, it is advisable to have the care of an anesthetist in and around the hospital if possible, or at least get a physician opinion before you do any procedure. Get a physician opinion, get the fitness, and then possibly have anesthetist in and around in-house. If you don't have somebody doing definitely a high-risk procedure, it's better to call an anesthetist at least for that procedure. Because it's not easy to get anesthesia for every hospital in every situation for local anesthesia. Correct. Even a local anesthesia patient can have a sudden cardiac arrest and die on the table. So that risk is always there. So it is advisable to keep somebody around, but do a pre-op assessment and get an assessment for fitness is generally advisable than having anesthetist for all cases. All cases is not mandatory.
You have to categorize based on whether it is high risk or low risk.
Stratify the risk.
And then if it is high risk, then definitely have an anesthetist.
Sir, if there is no risk, no established risk for the patient, a normal patient undergoes topical phaco and he lands up into cardiac arrest, then can the court say that because you didn't keep a standby anesthetist, so you are liable for it?
Yeah. Okay, so as per standards, we need to have a system in place for any emergencies. So other than the surgeon, there has to be a team trained in basic life support or advanced life support till the patient is resuscitated and you reach to a center for support like ICU or nearby hospital. So till then you need to have a team mandatorily trained in CPR and other support services. So other option is to have a anesthetist if it is available. If you have the resources, it's always safe to have an anesthetist even while operating under topical.
And sir, can we deny some patient, one question was there, a patient with ROP twins, they already had RD. So if we do, can we deny to see such patients? Like if we don't want to get into that loop of everything medico-legal, can we just say that no, we cannot treat this patient or we don't want to see the patient?
If it is an emergency, you have to treat, or at least attend, assess and then refer. Otherwise, if you feel that the patient is a high risk patient in terms of this medical legal risk, you can always politely refuse to attend the patient. It is your privilege to refuse patients.
Thank you.
Okay, so thank you all for for attending this session and also for making it very interactive. I'm sure all your queries have been answered. If anything, you can contact us. I thank the faculties, Dr. Murli, Dr. Sendil, Dr. Satyan and Dr. Niranjan for joining us for this session. Thank you so much. Thank you APAO and AIOS for this opportunity.
Thank you. Thank you, Nirmal.
Yeah. Thank you, sir.